Now we can speak?
Yes, we can speak. Everything is started.
Dear speakers, participants, and friends, let me introduce myself. I am Professor Said Gulyamov, head of the Cyber Law Department at Tashkent State University of Law. It's located in Uzbekistan. I am delighted to welcome you to the important conference, Rio de Janeiro Arbitration Week, promoting ADR culture locally and globally. And our section today is ADR 2.0, Mediation of the Future, how AI and neuroscience are redefining the rules of BRICS countries. The Republic of Uzbekistan has been actively developing its alternative dispute resolution system and institutions, and takes pride in being the part of the global ADR community. We seek deep involvement with the BRICS countries to exchange experience and adopt best practices. I would like to express my deepest gratitude to the main organizer, Professor Daniel Brandes Ferreira, CEO of the Brazilian Center of Mediation and Arbitration. Can I give you some minutes for the speech for the Professor Daniel Brandes Ferreira?
I guess no, because he left.
Okay. Anyway, and I would like to express my very close gratitude to my friend, Professor Yelizaveta Gromova. She is a professor and the specialist in the cyber security, cyber law, and today is one of the main actors and maybe one of the main people in the quantum law system. And let me introduce. I already introduced you, and I'll let you speak some words.
Yeah, dear participants and dear listeners, greetings from Russia. Of course, I'm here representing CBMA, where I'm the director for cooperation with BRICS. And what can I say? I can say that I'm really honored and happy to be here and to open these amazing events, because I'm a fan of my new friends and colleagues from Uzbekistan. The topic of your webinar is, really progressive, amazing. As a fan of digital technologies, I can say that you chose very interesting and highly relevant topic. And we already discussed that speakers also chose very interesting topics, and the list of speakers is really awesome. So I'm sure that today our listeners, they will know many new and very interesting information on the ADR. So thank you so much, dear Professor Said. Thank you so much, Professor Rustambekov, for this opportunity, both for international community to learn about how our digital technologies, including artificial intelligence and neuro technologies, can be used to make alternative dispute resolution better and more efficient. Thank you so much.
Thank you very much, Professor Yelizaveta Gromova, for your introduction and saying warm words about our section. And our section today is dedicated to the application of artificial intelligence and neuroscience in the field of alternative dispute resolution in BRICS countries. We will discuss trends and prospects for the adapting AI and in mediation processes, futures of the cyber arbitration, the influences of neuroscience on the mediation, ethical standards in the digital ADR, and much more. The goal of the section is to determine the development of the development path for the ADR 2.0 in the context of the BRICS, taking into account of the latest technological achievements. I'm confident our discussion will be fruitful and interesting, and I invite the speakers to present their reports. And first of all, and now I have the pleasure giving my first presentation on the topic of how the AI and neuroscience are transforming the mediation. In my talk today, I will discuss the key innovation in combating algorithms analyzing with the human judgment to enhance judgment systems in the BRICS countries. I will also explore opportunities to automatize routing court administration tasks to improve efficiency. But first of all, send me my permission to alter ego myself, Professor Gulyamov, to present my presentation. Please, let me. Cyber-symbiotic integration of AI and human judges in BRICS countries, enhancing justice through collaboration. Introduction. This research proposes integrating human and artificial intelligence capabilities in BRICS judicial systems through collaborative cyber-symbiotic frameworks. Such systems would combine the strength of human judges' life discretion, innate sense of justice, cultural awareness, and abilities for tireless, comprehensive evidence analysis and uncovering insights from vast datasets. The aim is to significantly improve the timeliness, consistency, transparency, and accessibility of justice delivery to help overcome endemic limitations like massive case backlog, inconsistent rulings across courts, and inadequate access to legal aid for disadvantaged populations across BRICS countries. Responsibly designed and ethically aligned human-AI partnerships can greatly expand access to more equitable, higher quality justice, especially for historically underserved groups lacking adequate representation. This emerging field of thoughtfully and prudently augmenting human judges with complementary AI capabilities has major significance and transformative potential for advancing substantial justice system reform and modernizing judicial institutions across BRICS countries. However, adequate precautions, including extensive audits, transparency mechanisms, and oversight control are vitally needed to mitigate risks around issues like algorithmic bias, opacity, and potential loss of human discretion or control that could undermine due process. Overall, this research explores a promising approach to significantly enhance judicial resources by harnessing synergistic human-AI capabilities for fair, timely, and universally accessible justice aligned with BRICS commitments to human rights and equal protection under the law, assessing needs and opportunities. Judicial systems in BRICS countries face major systemic pressures like massive backlogs of millions of pending cases that substantially delay and often outright deny justice delivery. For instance, India has over 30 million cases pending in lower courts, leading to long delays that infringe on citizens' rights to timely remedy. AI has significant potential to help address these acute limitations through capabilities like rapidly analyzing huge volumes of legal documents and case files, predicting likely case outcomes to enhance consistency, and providing preliminary automated case assessments to greatly improve accessibility to legal assistance. There are already many examples of successful and beneficial AI adoption in various public administration sectors across BRICS countries like tax filing, predictive policing, social welfare eligibility screening, and public health chatbots. These diverse use cases provide models for prudently and responsibly integrating advanced AI capabilities to modernize judicial institutions as well. Overall, thoughtfully and carefully designed AI applications can help alleviate systemic weaknesses, inefficiency, consistency, transparency, and access to justice across BRICS judicial systems if developed with strong safeguards against risks like bias. However, upholding rights requires keeping human judges firmly in charge of core adjudicative functions, while beneficially using AI tools as enhancements rather than replacements for human discretion and oversight. Model for human AI symbiotic judges. Human judges possess irreplaceable higher order abilities like innate sense of justice, cultural wisdom, nuanced contextual reasoning, empathy, and ethics. These invaluable human faculties crucially support rendering fair, equitable, and socially just decisions. AI systems possess complementary strengths like tireless analysis of vast volumes of evidence and legal data, perfect recall and information retention, unbiased pattern finding across huge datasets, and constant availability to address citizen needs around the clock. A proposed intelligent task allocation framework thoughtfully demarcates judgment-related functions as the sole purview of human judges, while delegating select evidence processing workflows and routine administrative tasks fully to AI automation, and delineating certain appropriate deliberations for collaborative human AI efforts. The envisioned model entails AI assistants providing a supportive role for judges by supplying data-driven insights and recommendations, while retaining ultimate human discretion over equitable case resolution and protection of individual rights. This defined division of labor based on respective human and AI competencies allows beneficially augmenting human judges with AI capabilities without replacing human oversight and accountability for arriving at fair and lawful outcomes. The framework is designed to be flexibly customized across the diverse BRICS country context. Technical solutions. The proposed architecture for an AI assistant to support judges highlights critical capabilities in natural language processing, predictive analytics, interactive interfaces, transparency and explainability mechanisms, robust security protocols, and human-centered design. Key functionalities needed include advanced legal reasoning skills customized for BRICS legal regime, multilingual communication fluency to serve diverse populations, transparent and fully interpretable analytical output, and seamless integration into existing judicial case management systems and workflows. Optimal interfaces should enable smooth, intuitive human-AI interaction with easy overrides of AI recommendations and on-demand explainability into factors influencing algorithmic outputs. Conversational agents leveraging natural language can provide an accessible, transparent user experience. Extensive customization catering to varied BRICS locales, legal code, languages, and cultural norms combined with rigorous security mechanisms will be critical implementation prerequisites. Focused R&D efforts embracing participatory design can help tailor and validate solutions for safely augmenting human judges' capabilities in a responsible manner without undermining rights. Overall, the aim should be frictionless human access to AI capabilities, while retaining judge oversight over consequential decisions through transparent and accountable AI design centered around human needs. Policy recommendations, laws, and regulations will need comprehensive reforms, updating frameworks to clearly define permitted versus prohibited AI roles, mandate full transparency, meaningful explainability, and accountability safeguards, while prioritizing the protection of due process rights and equal access to justice. Policies must achieve a prudent balance between enabling AI automation to drive efficiency gains versus emphasizing human control and oversight for sensitive judgment functions to uphold ethics. The adoption and governance of classroom AI across BRICS demands extensive audits, independent expert reviews, and substantive public consultations to align systems with societal values. Clear liability and redress frameworks must be instituted to safeguard citizens' rights and build public trust as courtroom AI capabilities expand. BRICS countries should collaborate to develop shared standards and best practices for responsible AI use respecting human rights, transparency, oversight, and saving discretion in legal decisions, with adequate precautions guided by human rights instruments. Cyber symbiotic courtrooms offer immense potential to further BRICS commitments to equitable access to timely justice. However, the risks necessitate vigilant governance. Conclusion. This research proposed a human AI cyber symbiosis model aiming to substantially enhance judicial resources in BRICS countries by combining complementary human and AI capabilities. The frameworks developed seek to meaningfully improve timeliness, consistency, transparency, and access to justice to help overcome systemic barriers like massive backlog, inconsistent ruling, and denial of representation that prevent vulnerable groups from equitable justice. Realizing these ambitious goals will require prudent governance, including clear division of labor protecting human discretion, extensive algorithmic auditing, explainability for AI systems influencing decisions, and substantive public participation to align courtroom technology with societal needs and values. Further research should extensively validate the proposed models through prototypes, empirical studies, comparative feasibility analyses across diverse BRICS nation contexts, and structured impact assessment. With diligent, thoughtful, and socially conscious development, human AI collaboration in courtrooms offer immense potential to significantly advance justice reform and modernize judicial institutions to be more responsive, accessible, and rights-respecting for all people in BRICS countries. Overall, the path ahead entails comprehensively integrating human and AI capabilities founded on strong oversight, accountability, and multi-stakeholder collaboration to help expand access to timely, high-quality justice, especially for historically disadvantaged groups across BRICS countries. Thank you for the attention. Thank you very much for your watching my video. And I've got several questions to my presentations, and they write me to the Telegram. And let me read their question. Thank you, Professor Gulyamov, for the presentation. First, what ethical boundaries need to be set when advising judges with the AI system? Could over-reliance on algorithms introduce a new biases? I believe that we must establish clear guidelines for the AI explainability and human oversight. I think that technology should assist, but not replace human judges, experience, and discretion. Ongoing review for the algorithms bias will be the critical in the future, I think. And I have another question. How might automating document filling the scheduling free up judges and courts to focus on complex legal reasoning? What benefits might this efficiency bring to the BRICS context? It's a very good, interesting question, and very interesting questions. And I think that AI could hugely reduce the administrative workload of the courts through the automatization. We already have it in the practice in our country, and I think that it's already used in other countries also. And this we already have the practice in this, and this will allow judges, but we have to make it more widely and make him like the advisor, not the only like the analyzing system. This will allow judges to dedicate more time to challenging issues requiring human judgments. Access to the justice could also expand by resolving block wars faster across BRICS nations. And we have small changes in our program because our judges right now in a meeting. And let me introduce, first of all, next after me, the Professor Islambek Rustambekov. He is it's my privilege to introduce Professor Islambek Rustambekov, the eminent acting rector of the Tashkent State Law University. In addition to his outstanding leadership in the legal education, Professor Rustambekov is an accomplished scholar and arbiter. Today, he will enlighten us on the vital topic of the future of international cyber dispute resolution through ADR in the BRICS countries. Please join me in the welcoming the Professor Rustambekov. Floor is yours, Professor Rustambekov.
Thank you so much, Professor Gulyamov and all participants. I am very honored to be here and participate in this event. And it's my privilege to speak on this actual topic. And I would like to present my presentation. And if you don't mind, begin to speak about the topic which I would like to present. And I hope that it is possible to see my presentation. Just let me to check it. Not this one.
It's mine. Yes, it's mine.
Yes, correct. Thank you. So I would like to speak briefly about the futures of international cyber dispute resolution through ADR in the context of BRICS countries' legislation. And as I was presented, I'm Islambek Rustambekov, professor and doctor of law and acting rector of the Tashkent State University of Law and international arbitrator and mediator. In recent decades, we have witnessed an exponential rise in international dispute related to cyberspace. Cross-border cyber conflicts ranging from cybercrime to state-sponsored hacking have grown rapidly. Traditional litigation pathways often prove ineffective for resolving these novel disputes due to jurisdictional complexities and the lack of technical expertise within conventional legal systems. Alternative dispute resolution, or ADR, offers more flexible and constructive procedures centered on dispute resolution expertise, interest-based dialogue, and confidential engagement between parties. Methods such as arbitration, mediation, and ombudsman processes have shown promise in addressing different categories of cyber dispute efficiently. However, research is needed to analyze the optimal application of various ADR techniques for the diverse range of cyber conflicts that can arise between citizens, corporations, and governments globally. A key aim is to formulate recommendations that can enhance the efficiency, legitimacy, and accessibility of ADR as an alternative to litigation for equitable and efficient cyber dispute resolution internationally. We would like to brief several core research methods to examine cyber dispute ADR, which included a systematic review of scholarly literature on both ADR principles and generally, and writings specific to cyber dispute resolution applications, analysis to the national laws and regulations around cybersecurity policy and ADR procedures in BRICS countries, and comparative case studies of existing cyber ADR cases are assessed to evaluate real-world outcomes. We would like to mention that the theoretical analysis revealed several key insights regarding appropriate applications of specific ADR methods for certain cyber dispute types, such as mediation. Mediation shows particular promise as an alternative avenue for resolving cross-border commercial cases, commercial disputes, and also some parts of the cybercrime disputes or cybersecurity disputes. Its flexibility can tailor solutions focused on rehabilitation offenders through mutual compromise instead of solely punitive measures. For cyber disputes arising from commercial relationships and contracts, international arbitration provides advantages such as enforcement of outcomes, procedural customization, technical expertise of arbitrators, and privacy protection that suit business needs. Online dispute resolution, or ODR, makes ADR far more accessible and efficient for addressing lower value consumer cyber complaints. However, the enhancement around security, ethical principles, and compatibility across jurisdictions are still needed. And when we speak about the ODR, like online dispute resolution, we also mention dispute resolution, so electronic dispute resolution, which is based on artificial intelligence. Because in the literature, we can see that in ODR, we often speak about the possibilities of including some methods of online dispute resolution, like online hearings, online submissions, etc. But when we speak about the electronic EDR, That means that everything is based automatically and it is based on artificial intelligence. And the main issue internationally, and there was a research of ICA that makes the research on the enforceability of the awards from ODR and EDR. And this can be an issue and requires additional making some amendments to the international regulations such as New York Convention and also national legislation of the countries regarding the enforcement of the ODR and EDR awards and regarding all these issues on these cases. And we can mention that also today internationally we already have such platforms for dispute resolution, which is more than 200. If we will go further, the further findings from the theoretical analysis include that ombudsman offices focused on consumer protection can provide a more accessible and impartial venue for resolving mass cyber harms like data breaches, but awareness and consistency of these schemes globally remains limited at present. For complex intellectual property and technology infringement disputes with cyber elements, mini-trial ADR combining facilitated settlement negotiations with neutral technical expert appraisal shows promise. However, the parties may still hesitate to compromise full legal rights without a binding ruling inhibiting adoption. And also additional theoretical insights show us that early neutral evaluation can provide efficient initial expert diagnosis of the merits in an organizational cyber dispute to assist subsequent negotiation, but may require supplemental enforcement mechanisms. Online dispute resolution utilizing automated algorithms and online mediators is highly efficient for resolving lower stakes consumer complaints and e-commerce disputes. However, limitations around enforcement and accessibility exist that require ongoing innovation. And several key procedural principles can help to adapt ADR methods to the novel context of cyber disputes. Flexible rules of procedure should be developed that are tailored for cyber-specific issues like online evidence gathering, technical expert involvement, and digital forensic best practices. Enhanced security standards need to be instituted for ADR providers to protect the sensitivity of cyber dispute records through measures like encryption and access controls. Remote participation should be enabled through video conferencing, cloud-based file sharing, and digital case management systems to facilitate efficient virtual arbitration, mediation, and ODR. Where suitable, artificial intelligence can be carefully integrated into ADR procedures to assist with document review, evidence analysis, and potentially even algorithmic mediation in certain low-value cases. Drawing on comparative case studies and academic literature, key findings on optimal ADR approaches for different cyber dispute types include mediation, includes the mediation first of all, and it's particularly appropriate for resolving cross-border, as we mentioned, commercial cases and also some types of cyber crimes or cybersecurity cases. International arbitration suits cyber disputes stemming from B2B, like e-commerce relationship and technology contracts, because from the commercial side, the international arbitration is already very popular to resolve the disputes in this sphere. Ombudsman schemes help provide recourse for consumer victims of mass cyber harms like fraud or data breaches. A hybrid mini-trial model combining arbitration and conciliation is promising for complex cyber intellectual property and technology disputes. And several practical enhancements to improve real-world cyber ADR processes are proposed as following. A default ADR clause framework should be developed for inclusion in commercial contracts prone to cyber disputes, outlining a graduated procedure escalating from mediation to binding arbitration if required. Sample mediation model procedures need to be formulated that are tailored for resolving international cybercrimes cases, such as selection of an expert mediator with cybersecurity credentials, anonymity of protections, and technical communication options to facilitate constructive engagement. Speaking further, specialized cyber arbitration rules and guidelines would also optimize this ADR method, including custom procedural rules addressing digital evidence collection, confidentiality protections, appointments of technical experts, and enabling remote participation, promoting competence of arbitrators in technology and multilingual dispute resolution through training requirements and recruitment policies. And this is very important, the promoting of the competence of the arbitrators and also mediators. Substantive principles to guide arbitrators in determining applicable law amidst gaps and complexities in global cyber regulations. And that was mentioned, is very important. And more specifics on beneficial cyber arbitration rules cover areas such as procedural rules allowing submission of digital evidence, remote participation, and appointment of neutral cyber forensic experts, heightened confidentiality standards, and cybersecurity requirements for arbitration materials and platforms, promoting arbitration competence in technology through training mandates and recruitment of panelists with relevant expertise, institution of pre-hearing evidence exchange procedures to narrow issues and improve arbitration efficiency. Guidelines on applicable law determination would direct arbitrators to respect express choice of law clauses in contracts that demonstrate reasonable nexus with the dispute, apply the domestic law most closely connected to the cyber dispute in the absence of specified governing law, supplement domestic law with established general principles of international law as needed when addressing novel cyber issues. And we would like to mention that when we speak about the applicable law, we also think that in future we need a new laws and new regulations regarding the cyberspace and cybersecurity issues and the cyber ADR and cyber cases. And that could be a cyber legislation, a special cyber legislation, which will regulate all these cyber cases issues which occur in cyberspace. And the next one, the discussion of study findings yields additional insights. While ADR methods are promising for certain cyber dispute profiles, careful selection and customization is critical for efficiency. No one-size-fits-all approach exists. Thoughtful procedural adaptations can enable cyber ADR to overcome complexities not encountered in traditional disputes, but human expertise remains essential. The lack of unified cyber regulations globally hinders consistent substantive law application by cyber ADR providers operating across borders. And the additional discussion considerations include the capacity building around infrastructure, trained personnel, enforceability mechanisms, and other foundations remains imperative for cyber ADR success, especially among less resourced nations. Critics regarding transparency, accountability, and risks of automation warrant continued analysis to strengthen the inclusiveness of cyber ADR design. Excluding non-BRICS world perspectives omits valuable insights that would enrich formulations of inclusive global cyber dispute resolution systems. Mainstreaming informal ADR at the potential expense of binding cyber legal norms carries certain trade-offs requiring deliberation. And in conclusion, we want to mention that this study and this presentation offers several contributions to the advancement of cyber dispute resolution. It provides a structured comparative analysis of real cases, academic literature, technical frameworks, and cultural perspectives on cyber ADR. The tailored recommendations and future research agenda offer pathways for ongoing enhancement of cyber ADR mechanisms. Customized, ethically applied ADR processes present constructive alternative to escalating cyber conflicts. And at time, I would like to mention that we are also working on the possibility of establishing of a new cyber arbitration center in Uzbekistan, which will provide new mechanisms of dispute resolution as an arbitration center for the new cases in cyberspace, which are becoming a very new technological cases regarding the digital assets, digital investments, and other new perspectives of the new cases in this sphere. And we hope that we will be able to bring in future a new center, a new arbitration rules and regulations for the cyber disputes. And thank you for your attention.
Rustambekov for illustrating the complex intersection of the technology, arbitration, and justice across BRICS nations. Let's explore some few questions for you. I prepared several questions for you. What unique security measures are needed to protect confidential data in the virtual arbitration proceeding? And how can cyber arbitration balance efficiency and information protection?
Thank you very much for this question. And I would like to mention that encryption, access limitations, and robust cybersecurity will be critical regarding this question. And this is the main points for the protection of confidential data in the ODR and arbitration. But also, so we will clear guidelines and trainings to ensure arbitrators and sides use virtual tools responsibility are very important. So the first of all is also we need to mention the capacity building in this sphere, and that will be important. And the most important thing is I'm also as an arbitrator and a board member of several arbitration institutions. We often use such a special programs and points for the discussions, etc. And still we think that these systems are working well, but it should be improved, and cybersecurity issues will be very important, and we need to work on that further. So thank you for this question.
And I have another question. As more cross-border businesses disputes move online, how can arbitral institutions adapt for the new jurisdictional complexities? What guidelines is needed here?
Thank you for this question. This is a very important and correct question, I think. The clarifying governing law and arbitration venue in advance is essential when parties are in multiple countries, and institutions will need to provide greater support navigating multi-jurisdictional cases. And as I mentioned in my presentation, it is very important to improve the legislation in this sphere, the international rules like New York Convention, and also the arbitration institutions and mediation institutions should improve their rules regarding the ODR and EDR methods of dispute resolution, and that is critical, important thing for nowadays.
Thank you very much. Let me introduce my next speaker. Our next presenter needs no introduction, but in my privilege to introduce such an esteemed scholar, Professor Akhtam Yakubov serves as director of Karshi International University and is an international renowned expert on the intersection of the neuroscience and mediation. His pioneer research has revealed groundbreaking insights into the cognitive processes underlying conflict resolution. Today, he will share findings on the influence of neuroscience on the mediation in BRICS countries, a topic which profound implication for the mediation theory and practice. Please join and welcoming the Professor. Floor is yours.
Assalamu alaikum. Good afternoon, everyone again. It's honor to me here to participate. And with your permission, I'm going to move to my presentation as my coach, Mr. Professor Gulyamov introduced, the topic is the influence of neuroscience on the mediation process in BRICS countries. So, yes. Emerging neurotechnologies, including the functional MRI and EEG, offer new abilities to read and interpret brain activities during the pivotal mediation process, like perspective taking, empathy building, and decision making. So, neuroscience theories and empirical findings suggest the potential for these kind of technologies to enhance mediator skills and the techniques aimed to fostering mutual understanding between disputants and overcoming cognitive biases that impede settlements. However, neurotechnology integration also poses risk around the issues like privacy violation, lack of proper consent safeguards, and the potential for manipulative or exclusionary measures to these powerful capabilities. Currently, there are minimal regulations governing the applications of neurotechnologies in mediation contexts across the leading emerging economies of Brazil, Russia, India, China, and South Africa. So this studies aims to critically analyze the relevant neuroscience concepts, map regulatory gaps in BRICS countries, and propose evidence-based principles and guidelines to promote responsible advancement of neurotechnology integration in the mediation process in a manner aligning with the ethical values. So the literature and the intersection of law, neuroscience, and dispute resolution offers valuable analysis of neurolaw issues and neuroscience insights regarding the brain function during the conflicts. However, minimal academic focus exists on the government's issues surrounding the integration of neurotechnologies, specifically in the mediation context. The relevant legislation like India's Mental Health Care Act and the European Union's General Data Protection Regulation establish primary privacy and the consents to safeguard that could inform formal mediation neurotechnology regulations. These studies will conduct an extensive qualitative meta-analysis of neuroscience theoretical and empirical findings of brain process during the key mediation task through the database search and the thematic analysis. It will also employ the comparative methodology to map and examine policies and regulatory gaps related to the applications of neurotechnologies in mediation across the BRICS countries. Cultural factors shaping governance approaches across BRICS members will be analyzed to inform cohesive, context-sensitive guidelines for responsible advancement of the mediation neurotechnology use. So the neuroscience research has guaranteed values insight into brain function during the key mediation task, like perspective taking and trust bindings. Theorizing around the mirror neurons helps explain how mediators adapt at perspective taking mentally simulate other expressive by leveraging my mirror neuron use system. Findings on neurotransmitters like oxytocin and dopamine reveal how conditions enable their release can biologically encourage trust and cooperations between disputants. Implications for mediators include the pursuing training to consistently deploy mirror neuron function for the perspective taking and employing techniques that create positive environments facilitating neurochemical trust mechanism. However, biochemical shortcuts should not replace mediators' core skills and ethical integrity. While promising, neuroscience offers no quick fixes overriding humanness and sound judgment in mediation. Then neuroscience offers useful perspective on inherent cognitive bases that frequently implement conflict resolution. fMRI studies real hope-based like reactive devaluation, active emotional brain regions, providing mediators targeting insights to design technical interventions. Emerging EEG and FRS neurotechnologies can detect emotional like anger, sadness, and joy fairly accurately through the neurosignals, allowing mediators to gauge feelings and respond appropriately. Looking ahead, advances in real-time functional brain imagining and the machine learning may one day enable the algorithms to predict cooperative and adversarial behavior seconds so before the action occurs based on the brain data patterns. This could facilitate primitive mediation guidelines to diffuse tensions. However, behavior prediction through the neurotechnology remains limited technically and ethically. Key challenges around the privacy, consent, and avoiding the assumptions based on the main data need addressing before such capabilities can be responsible, harness, and enhance mediation. And in summary, pivotal theoretical insights from the neuroscience include the first is the human brain's mirror neuron system facilitates perspective taking skills by enabling to model others' mental states based on the observable cause. Masters mediation adaptly leverage the mirror neuron system to promote mutual understanding between disputants. The second one is neurotransmitters like oxytocin and the dopamine encourage trust and the cooperation by reducing social fears and rewarding the collaborate behaviors. The mediators can create conditions that actively these neurochemical phases. The next one is recognizing inherent cognitive base allows mediators to design targeted interventions to overcome mental barriers impending dispute resolution. And the next one is emerging neurotechnologies can detect emotions from the brain activity, granting the mediators to develop emotional intelligence to guide the negotiations adaptively. And the last one, the future advance may support capabilities like a behavior predictions and the direct brain-to-brain communication for radically improve the mutual understanding. So responsible governance and the ethics are critical to ensure the neurotechnologies and expand access, insights, and justice rather than to create unacceptable risks. So they transformative potential necessities purpose driven advancement. And while neurotechnologies is increasingly informing mediation, its direct integration in process remains limited, but the gradually expanding across BRICS countries like China, India, South Africa, and Brazil. However, growth is concentrated by insufficient user-friendly tools designed especially for mediation contexts. High cost, limited access main Wesley users, like a lack of clear regulations and policies governing responsible development. BRICS members exhibit diverse regulation approaches and to neurotechnology, spanning South Africa's proactive governance efforts to China's state-driven proliferating without the rights protections. Across the BRICS, major gaps exist around the formulating concept protocols, ethics, codes for mediators, training and certification requirements, technical standards, and accessibility safeguards related to the neurotechnology application in mediation. Compensatory, national policies are imperative to enable responsible advancement for this promoting but the ethically sensitive integration of neurotechnology within the mediation domains across BRICS countries. And integrating neurotechnology within the mediation also poses major risks, including the threats to privacy, personal autonomy, consent, accessibility, and the dispute resolution fairness that the necessitative principles governance approach. Proposed guiding principles emphasize designing applications to empower rather than exploit participants, restricting the use based of opportunity and the necessary principles, ensuring the universal access and the mandating informed consent protocols. Recommended regulation encompass requiring licenses and specific training for the mediation using the neurotechnology, formal consent procedures, technical standards, secure data policies, oversight bodies of investigate ethics badges and accessibility provisions, establishing certified training programs covering the mediation neuroscience. Ethics and applied skills could be crucially enable accountably clarify the use of neurotechnology capabilities by the equipping mediators with essential knowledge. Responsible neurotechnology integration in the mediation hints on the comprehensive policies approaches addressing risk based on the risk-considered principles. And like a proposed framework for harmonizing mediation neurotechnology regulations across BRICS countries include implementing consistent licensing protocol for ethical, like credential use, establishing aligning training programs covering course-specific scientific, technical, and ethical competencies, adopting the sharing informed consent principles, representing the participant rights, and formulating the coordinate code of ethics or neurotechnology signed mediation and manually recognizing technical standards optimized for valid, useful applications, and developing the interpretable data protection standards safeguarding confidentiality, and conducting cross-jurisdictional test programs to enable collective learning, and creating the BRICS Neuro Law Council to exchange insight and coordinate policy evaluation. So, such as a BRIC-wide harmonization can accelerate advancement of mediation neurotechnology across the sharing foundation of human rights protections, accountability mechanism, and the practice standards for public benefit. So it will be pioneer to an integrated governance model with the potential for global impact. And in summary, the key findings relevant increasing the but still limited integration of neurotechnology in mediation context worldwide and especially across BRICS countries. However, the major regulatory gaps exist, which has required urgent reforms. So contribution, including the elucidating how neuroscience can enhance mediation techniques, documenting emerging real-world uses, proposing the governance framework tailored for the BRICS members, and constructively examining understudies the risk and challenges. Implementation highlights can need for national legislation and international agreements, instituting human rights safeguards and the professional ethical standards around the neurotechnology in mediation. Proposed licensing system, training outlines in the BRICS coordinations models offer policymakers tangible ways forward for building mediator capacity and harmonization standards to responsibly harness neurotechnologies, promoting capabilities for the conflicts resolution. And in conclusion, key finds from these exploratory studies relate limited but the gradually increasing integration of neurotechnology and mediation contexts worldwide and across BRICS countries. However, major regulatory gaps exist requiring urgent interventions. Contributions include the mapping this emerging landscape and proposing governance framework to enable responsible, right-based advancement. Recommendations emphasize the needs for urgent policy reforms, professional ethic codes, and multilateral collaboration and harmonization standards for nanotechnologies used in mediation, and limitations like a phrase use data and the Western country precedents highlights fruitful areas for future research as applications accelerate globally. So this study hopes to provide the constructive foundations of insights to see nanotechnology trajectory in mediation responsibility toward enhancing access to the justice worldwide. With care and wisdom, we can share its far-reaching implications for human progress collectively. So thank you for your attention. Thank you, everyone. I finish my presentation.
Fascinating view for neurobiology of the mediation. Your work is truly pushes the boundaries of our understanding. If I may, I'd like to pose a couple of questions to you. And firstly, if you allow me, your research on minor suggestion we may actually be hardwired for empathy. And how might we translate this knowledge into enhanced skills training for the mediators? It's a very complicated question. And are there specific techniques we should teach to activate mirror neural pathways?
Yeah, thank you for your question. Yes, this is a specific area is coming to the that's a medicine and the law mixing way. So new understanding is coming to the this area. Here is a specific training courses, training programs we're supposed to provide the mediators, and we give the instructions. We give the such kind of the settlements. So in this way, we can kind of the come to one point together.
And let me, like a rule already, can I ask you a second question? How we can apply insights from the neuroplasticity in an ethical way? For example, avoiding manipulation of vulnerable brain states during mediation. Are the risk mediators should be cognizant of here?
The first of all, we're supposed to become here to make a regulation basis. So ethical codes, ruling materials. Then here is a kind of the divided the meanings. The one side says no, we cannot use this kind of techniques during the mediation. The second says yes, it's possible. Here is a specific kind of the settlements, kind of the devices, so it can be shown. So the if I conclude to the answer, before the pushing the
Микрофон выключился. Your microphone is not working. Yes. Oh, yes.
Probably yes, with a connection.
Thank you very much, Professor Yakubov, for your really interesting presentation. And
Thank
we
you.
have our next. We have our next speaker is Professor Mokhinur, but we have some link connections, and that's why let me introduce our next speaker. Mokhinur is here. Yes.
Yes, Assalamualaikum. I'm here, doctor.
1 second. Yes.
Okay.
It's my pleasure to bring the virtual stage for Professor Mokhinur Bakhramova, eminent scholar of digital diplomacy. As a professor of business law and a proponent at tech available governance, her insight on ADR are invaluable. Today, she will address the role of digital diplomacy in ADR in BRICS countries, a timely topic as we increasingly leverage technology to transcend borders. Please join me in welcoming Professor Bakhramova. Floor is yours, please.
Thank you very much for your warm words, Dr. Gulyamov. And assalamu alaikum again. Good day, dear guests and participants. My name is, as Dr. mentioned, Dr. Mokhinur Bakhramova, and I'm an associate professor at Tashkent State University of Law. And it's an honor to participate in this international conference. And let me thank dear Dr. Elizaveta Gromova for her invitation and attention. And today I'm going to present my presentation of work regarding the role of digital diplomacy in ADR processes in BRICS countries, current challenges, and new solution strategies. Okay. In first slide, we can see that the role of digital diplomacy in ADR processes in BRICS countries. The emergence of new information and communication technologies is transforming practices of alternative dispute resolution worldwide. The study examines how principles of digital diplomacy could enhance engagement in online mediation, arbitration, and other ADR processes involving the BRICS nations of Brazil, Russia, India, China, and South Africa. We outlined current legislative frameworks related to use of technologies in BRICS ADR and analyzed remaining challenges around issues of jurisdiction, enforcement, and cultural divergence. Drawing upon digital diplomacy theory and models, we propose strategies to promote transparency, inclusion, and cooperation in technology-assisted BRICS dispute resolution. Our findings aim to provide guidance on adapting ADR to the digital age while upholding core values of harmony and mutual understanding. The research employs mixed methods of approach combining qualitative, quantitative, and comparative techniques to conceptualize and evaluate the proposed digital neutrality framework. In-depth interviews with mediators will gather insights into real-world ethical challenges and potential benefits and limitations of adopting digital neutrality. The surveys will quantify the prevalence of online mediation and assess mediator viewpoints on digital competency needs. Comparative analysis will benchmark digital neutrality against existing mediation codes of conduct. This multifaceted methodology aims to ground the digital neutrality model in empirical data while relating it to prevailing ethics standards. In this slide, we can talk about the key theoretical results on conceptualizing digital neutrality. The research makes several notable theoretical and contributions to conceptualizing digital neutrality in ethical framework for online mediation and dispute resolution. First, it proposes an original definition of digital neutrality as an orientation upholding core ADR principles like impartiality, informed consent, and transparency as practices migrate online. Second, key dimensions of digital neutrality are elaborated, including duties around minimizing bias, enabling participating, protecting privacy, ensuring accessibility, and allowing participant autonomy in technology use. Third, digital neutrality is shown to strongly align with foundational ADR values of collaboration and empowerment, access, and self-determination. Together, these theoretical findings provide vital conceptual grounding for the proposed digital neutrality mode. Evaluating benefits, critics, and ethics underpinning digital neutrality. This research analyzes several advantages of digital neutrality framework, including providing coherent principles to guide ethical online ADR and promoting transparency and improvement of digital platforms. However, limitations are also discussed, and such as potential barriers to implementation and risks of overregulation. Critics may argue digital neutrality wrongly prioritizes technology over fundamental ADR ethics. In terms of ethical foundations, digital neutrality aligns with elements of deontological duties, utilitarian benefits, contracting consent, pragmatic adaptation, and relational equality. Examining merits, drawbacks, and philosophical underpinnings provides a robust evaluation of the proposed digital neutrality model. Implementing and contributions of the digital neutrality concept. The research proposes various strategies for implementing digital neutrality in practice, including new training programs, model codes of conduct, and public outreach. The concept makes several key contributions, including articulating the first tailored framework for addressing ethical risks in online dispute resolution. It provides guidance on upholding core ADR principles like informed consent within digital contexts. The research highlights mediator duties around platform selection, minimizing bias, ensuring accessibility, and protecting privacy. By outlining implementation pathways and synthesizing insights from law, ethics, and ADR, this study aims to establish practical and ethical foundations for technology assisted dispute resolution. Drafting and benchmarking an ethical code of conduct for digital neutrality. The research makes practical contributions by drafting an original ethical code of conduct aiming to translate digital neutrality principles into coherent guidelines for mediators. The code covers duties across 6 key areas, including impartiality, informed consent, participant autonomy, privacy, accessibility, and mediator competence. Comparing the draft code to existing standards reveals certain novel inclusions responding to digital contexts, such as algorithmic bias, informed consent for artificial intelligence, data minimization, accessibility barriers, and improving digital competency. Benchmarking shows the proposed code incorporates familiar ethics while expanding guidance on priorities for ADR's digital future. Revising the digital neutrality code based on practitioner feedback solicited qualitative feedback from ADR experts to strengthen the draft digital neutrality code. Key critics related to clarifying security standards, allowing cultural preferences, emphasizing continuous consent education, advising on surveillance laws, avoiding disability generalization, and balancing transparency. Incorporating the input led to notable code revisions, including referencing security benchmarks, adding cultural adaptability language, describe informed consent as ongoing process, advising legal consultation, using individualized disability terminology, and allowing flexibility during temporary system failures. Expert consultation improved the code's clarity, inclusiveness, and practicality for real environment. Ongoing refinement based on end-user perspectives can enhance adoption and impact. Training, testing, and implementation recommendations for the digital neutrality code. The research proposed training programs on the code using multimedia tutorials, webinars, reflective writing, and mentoring. A voluntary test program is recommended to evaluate real-world impacts, gathering quantitative compliance data and qualitative feedback from diverse mediators. Outcomes would inform final implementation recommendations like revising specific provisions, providing supplementary resources, allowing contextual customization, incentivizing training completion, co-creating versions with partners, conducting further research, and developing model legislation. This staged approach can refine, socialize, and eventually embed digital neutrality ethics into mainstream alternative dispute resolution. Discussion, digital neutrality findings, contributions, and future research. It aimed to conceptualize digital neutrality for ethical online dispute resolution. Key findings validate needs to address risks around device, consent, privacy, accessibility, and competence of mediators in virtual environment. Theoretical and practical results demonstrate adapting core ADR principles to technologies through specialized training, code of conduct, and participatory design. Contributions include articulating a tailored conceptual framework, proposing implementation strategies, and emphasizing proactive mediator roles in shaping ethical technology deployment. Future research could test training programs, survey practitioners' viewpoints, explore cultural values, integrate inclusive design thinking, partner on technological solutions, and refine digital neutrality as emerging technology develop. In slide 10, we can see that how we concluded our research work, summary of digital neutrality framework and contributions. In conclusion, in this research from concerns about maintaining core of ADR principles as practices shift online, findings affirmed needs to proactive policies and competences to sustain values like impartiality, consent, and privacy virtually. Contributions include conceptualizing an original tailored framework called digital neutrality, outlining mediator duties and implementation strategies. Additional contributions encompass emphasizing co-regulation approach, judicially leveraging technology innovations, modernizing neutrality concepts for digital contacts, and demonstrating participatory methods to develop guidelines. Limitations include the need to expand research across cultures, technologies, and ADR roles. Future directions involve participatory refinement, experimental studies, auditing algorithms, and explorations of emerging practices. Sustained inquiry can help align dispute resolution innovation with humanistic values in the digital age. And that's all. Thank you very much for your attention. And if you have any questions, I'm ready to answer them. Thank you.
Thank you very much, Professor Bakhramova, for your highlights for the digital diplomacy can strengthen the mediation globally. Let's explore a few questions for you and these emerging trends. Firstly, how can online negotiation platforms balance efficiency with the human relationship in cross-cultural mediation? What guard rails are needed?
I finished it, doctor?
My question is, how can outline negotiation platforms balance efficiency with the human relations in a cross-cultural mediation? What guardrails are needed?
Okay, thank you for your question. An additional contribution I can encompass emphasizing co-regulation approaches, judicially technology innovations, and modernizing neutrality concepts for digital contacts, and demonstrating participatory methods to develop guidelines. And limitations can include the need to expand expand research across, as I mentioned before, the culture, technologies, and ADR roles. As we can say that the future directions for developing of usage of ODR online in online virtual world, it can involve participatory requirements, experimental studies, auditing algorithms, and exploration of emerging practices. For usage of ODR, the parties should sign a contract, and if all the parties are ready to obey the contract, they can start the hearings before the online virtual mediator.
Thank you very much. And I have one more question, if you allow me. What data security measures must be in place for online mediation involving state actors, and how can we mitigate confidentiality risks?
Thank you. That's a very interesting question regarding to cybersecurity of the participants of the parties. And in our this research, we trained proposed programs on the code of using multimedia tutorials, webinars, reflective writing, and mentoring. And the voluntary test programs is recommended to evaluate real-world impacts, gathering quantitative compliance data and quality feedback from diverse mediators. Regarding to your question, to keep all the information about the participants, they should sign the contract to obey the confidentiality during the process, and its outcomes would inform final implementation recommendations like revising specific provisions, providing supplementary resources, allowing contextual customization, incentivizing training complementations, and creative reversions. I think all this depends on the to the center to where the parties are delivering their cases
Thank
regarding
you very,
to uh, cases even safe.
Thank you very much, Professor Bakhramova. It was very really interesting uh, speech about this digital diplomacy. I hope your next research will be more interesting than this. And let me uh, give a floor to the another speaker. But dear colleagues, unfortunately, our esteemed speaker, Professor Jahangir Juraev, is unable to join us live today uh, due to the importance of Supreme Court meeting. And however, he has prepared a video presentation sharing his invaluable insights on the adaptation of AI in mediation in BRICS countries. Professor Juraev sends his apologies that he cannot be here in person, but he's in delighted to contribute virtually on our important discussion. Now I invite you to view his pre-recorded remarks, please.
Adapting artificial intelligence in ADR processes in BRICS countries' trends and prospects for the next 20 years. Adapting AI in ADR in BRICS. Since the 1990s, there has been an accelerating rise in investment and adoption of artificial intelligence technologies in the legal domain. AI is increasingly recognized to have noteworthy potential benefits for processes related to alternative dispute resolution, ADR, including improved efficiency, enhanced accessibility, and data-driven insights that can inform dispute settlements. However, AI integration also poses risks around issues like algorithmic bias, lack of transparency, and the erosion of human discretion that necessitate a cautious, responsible approach focused on integrating these technologies in an ethical manner. This study aims to thoroughly analyze the current state of AI adoption in ADR contexts across the BRICS countries of Brazil, Russia, India, China, and South Africa. It also proposes a comprehensive strategic framework to guide the integration of AI capabilities in BRICS countries' ADR systems in a measured, socially conscious manner over the next 20 years. Research methodology. This study utilized a rigorous, systematic methodology to construct the proposed strategic framework to guide AI integration in ADR. It conducted an extensive analysis of academic publications, journal articles, and books on the subjects of artificial intelligence, RJAW, and alternative dispute resolution to synthesize relevant theoretical insights from scholars. Detailed document analysis thoroughly examined the relevant national policies, legislation, regulations, and ethical codes in each of the BRICS countries to discern the policy contexts and baseline governance landscapes surrounding AI and ADR. Rigorous qualitative and quantitative research methods were applied to identify key themes, opportunities, risks, and challenges frequently highlighted across the literature. Deductive reasoning helped methodically derive feasible policy recommendations from the synthesized theoretical and empirical insights. Comparative analysis elucidated similarities and differences between BRICS countries. Conceptual modeling methods illustrated relationships between core factors influencing AI in ADR systems. Logical argument mapping techniques evaluated chains of reasoning on AI risks and benefits. The combined application of these analytical techniques provided a rigorous methodology tailored to BRICS contexts. Theoretical perspectives on AI in ADR. Precisely defining key concepts provides vital conceptual foundations to assess capabilities and limitations of artificial intelligence technologies versus human cognition's abilities. This grounds evaluations of where AI systems can potentially augment human judgment in ADR processes versus areas where human discretion and subjectivity remain completely indispensable. Reviewing technology adoption theories like diffusion of innovations and the technology acceptance model offers useful insights on pragmatic factors like relative advantages, compatibility, demonstrable benefits, and user literacy that may facilitate or hinder the integration of AI innovations. Analyzing arguments highlights the transformative potential of AI in enhancing access, providing data-driven insights, and improving efficiency in alternative dispute resolution, if the technologies are pursued cautiously under human oversight and participative governance. Focus is needed on developing AI to actively augment and complement, not replace, human capabilities and discretion in the ADR domain. Establishing conceptual clarity and grounding recommendations in technology adoption theories helps ensure the ethical, equitable integration of AI in alignment with human-centric ADR values. Assessing AI for ADR tasks and future outlook. A sober assessment of current AI capabilities indicates machine learning systems can enhance the efficiency and accessibility of administrative ADR functions like scheduling and document handling through automation, though adaptability to unexpected changes remains a human strength. However, present-day AI still falls remarkably short in accounting for nuance, ambiguity, subjectivity, and relationship dynamics, human faculties that remain completely vital for tasks like conflict analysis, mediation, and higher-stakes arbitration. Though AI shows promising potential to assist tasks like legal analytics, case law analysis, and recommending settlement options aligned with precedents and principles if subjected to ongoing human oversight on outputs. Effective computing could aid understanding of emotions and relationships between disputing parties if privacy risks are thoughtfully addressed upfront. Advances in explainable AI techniques and conversational interfaces may moderately increase AI's interpretability and ease of use for certain limited dispute resolution functions over time. However, human discretion, judgment, and ability to weigh various factors remain essential to equitable outcomes. Sustained focus is imperatively needed on developing AI in ways that ethically augment and empower, rather than replace, innate human capabilities and ingenuity in ADR processes. Explainable AI increasing interpretability could alleviate opacity concerns. Conversational AI user-friendly virtual assistants could aid engagement key to emphasize developing AI to augment human capabilities and discretion in ADR, not replace them. Sustained focus needed on ethics, human rights, and values alongside innovations. Challenges and oversight needs for ethical AI in ADR. Realizing responsible and ethical integration of artificial intelligence systems in alternative dispute resolution processes with their unique priorities and values requires proactively engaging with several complex challenges at the intersection of technology and society. A core challenge is the fact that training data used for developing AI systems inherently reflects embedded societal biases, lack of representation, and structural discrimination. If these problematic data inputs are not adequately addressed through ongoing audits, impact assessments, and vigorous mitigation methods, deployed AI systems carry enormous risks of further entrenching and even amplifying unequal, unethical outcomes. Enabling meaningful participation of impacted communities, civil society advocates, domain experts, and other stakeholders in the design and development of AI systems can help build essential trust, but genuinely inclusive, participatory technology design processes face inherent logistical difficulties and inertia barriers that must be frankly recognized and actively remedied. Additionally, humans have inherent cognitive limitations in our ability to sufficiently understand and scrutinize the complex, opaque algorithms, and massive data models underlying many AI systems that are currently being considered for integration into the ADR domain. Achieving truly robust oversight most likely necessitates bringing together transdisciplinary teams combining legal, technical, and social science expertise, paired with extensive monitoring of real-world system performance across diverse populations and regular auditing of outcomes. Floating aspirational ethical principles and codes of conduct must be actively translated into concrete organizational practices, processes, incentives, and culture through practical mechanisms like policies, guidelines, trainings, and audits to drive adoption and accountability. Prior experiences across multiple sectors have repeatedly proven that voluntary, piecemeal adoption of ethics at the surface level is wholly inadequate for engendering responsible innovation in contexts with significant impacts on human rights and the public interest. Instead, core ethics principles need to become firmly embedded into the organizational DNA through integration in areas like human resources, procurement, impact assessment processes, and governance structures. As advanced algorithmic systems are given increasing levels of influence over impactful decisions and functions in the ADR domain, difficult yet important questions arise regarding individual and group rights to effectively contest AI-assisted determinations and appeal any adverse impacts on human rights or dignity through procedural justice mechanisms. New procedural rights and accountability structures adapted to the unique issues posed by automation may be vital for upholding due process when integrating AI capabilities into sensitive dispute resolution systems. Lastly, responsible innovation must be understood as an iterative, ongoing process that requires sustained commitment to periodic reevaluation of benefits against emerging risks, not a one-time checklist. Governance frameworks and principles for AI in the ADR sphere will likely need regular reassessment and continual adaptation by diverse stakeholders to keep pace with the rapid pace of technological transformations. Proposed BRICS principles and policies for AI in ADR. Conduct regular foresight studies to anticipate emerging technologies relevant to law and ADR. Allows proactive governance evolution. Develop AI expertise among mediators, arbitrators, and ADR professionals via training programs. Enables accountable adoption. Promote public awareness of AI issues like bias through outreach campaigns. Fosters support for human-centric policies. Craft clear ethical guidelines for AI in ADR tailored to national contexts. Can catalyze values-driven innovation. Enabling contestability of AI decisions multi-stakeholder governance. Guarantee individuals' rights to contest automated AI determinations influencing ADR outcomes. Create channels for ADR users to voice objections to algorithmic decisions affecting them. Require explainability of contested AI outputs to enable oversight. Establish independent expert panels to evaluate appropriateness of algorithmic decisions. Make contestation processes accessible and straightforward for the public. Form multi-stakeholder bodies governing AI integration with diverse representation. Ensure plurality of viewpoints and structured dissent. Conclusion. Study proposed strategic framework for judicious AI integration in BRICS ADR over 20 years. Key findings: AI holds transformative potential, but risks necessitate cautious, ethics-centered approach. Recommendations emphasize participatory design, auditing, transparency, contestability, multi-stakeholder oversight. Sustained, inclusive deliberation needed as capabilities progress. Priority next steps: expert panel, hackathons, public outreach, legislation, collaboration network, research funding. With coordinated action guided by humanistic values, BRICS can lead in developing AI governance ecosystems that center justice and empowerment. Thank you for the attention.
This was the presentation of Jahangir Juraev, adapting artificial intelligence in ADR process in BRICS countries, trends and prospects for the next 20 years. Now, let me give the floor to our next speaker. Dear colleagues, unfortunately, our distinguished speaker, Professor Sadogat Safoveva, is also unable to join us live today, and they have the important Supreme Court session, and that's why she has prepared a video presentation to her invisible insights, invaluable insights on the evolution of ethical norms in digital ADR. Professor Safoveva sent her regrets that she cannot participate in person, but is excited to contribute virtually on this critical topic as we integrate emergency technologies into ADR. And now invite you to view her pre-recorded remarks, and we look forward to thought-provoking discussion afterwards. Thank you very much, please.
The evolution of ethical norms in digital ADR experiences and prospects for BRICS countries. Digital technologies like AI, virtual platforms, and predictive analytics are rapidly transforming alternative dispute resolution processes globally. However, established ethical principles and codes of conduct have generally not evolved at the same pace as these innovations, resulting in concerning regulatory gaps, risks, and uncertainty around digital ethics, especially across BRICS nations. This study aims to critically analyze how traditional ADR ethics and guidelines can adapt to address emerging issues posed by new technologies. It offers both theoretical frameworks and practical recommendations tailored to the BRICS context for updating codes of conduct to balance innovation with time-honored dispute resolution values of justice, autonomy, and transparency. Key objectives include evaluating the landscape around digital ADR ethics in Brazil, Russia, India, China, and South Africa, proposing models for dynamically adapting norms to technology and guiding ADR professional bodies on training programs, oversight mechanisms, and sample code revisions to implement updated standards that align ethical principles with the digital transformation. This study employs an integrated mixed methods approach to develop contextualized recommendations tailored to the BRICS environment. First, an extensive literature review synthesizes current knowledge on emerging technologies in ADR and ethical issues globally and in BRICS nations specifically. Limitations in BRICS-focused scholarship are revealed. Second, systematic analysis of widely adopted ADR association ethical codes and conduct standards identifies common principles and gaps regarding digital ethics guidance. Third, documented use cases of technologies like AI in legal and ADR contexts across Brazil, Russia, India, China, and South Africa are evaluated to understand regional challenges and best practices. Fourth, these qualitative findings are integrated to develop original, culturally attuned frameworks for updating ADR ethical guidelines in the digital age. While primary BRICS data is limited, the mixed methodology ensures a rounded, pragmatic perspective grounded in literature, theory, and case analysis. However, empirical research remains needed to directly survey BRICS stakeholders on experiences with technology-enabled ADR. This study's evidence-based proposals can inform such future scholarship while serving the timely need to adapt traditional ADR ethics for emerging innovations. This research reveals important theoretical insights into navigating the digital transformation of alternative dispute resolution. First, there is an interdependent relationship between evolving ethical standards and advancing technological capabilities, requiring coordinated coevolution. As innovations like AI and virtual platforms integrate into ADR, associated risks also emerge, creating pressure to adapt principles around transparency and consent while retaining core values. Second, an innate tension exists between fully capitalizing on emerging technologies and upholding timeless ADR principles centered on party autonomy, impartiality, and human control. With thoughtful governance, innovation, and enduring values can complement rather than compete. Finally, current codes of conduct and regulations often lag behind technology capabilities, revealing an evident need for ethical frameworks to consciously evolve alongside ongoing tech advances through continuous code revision, progressive laws, and competency building. Key is conscious, preemptive adaptation of principles, guidelines, and oversight to harness innovation for efficiency and insight without compromising on justice, voluntary participation, and human discretion in the digital era. Ethical evolution must match the pace of technology change. A proactive framework is proposed to dynamically adapt ADR ethical codes as technology advances. This involves continuously monitoring emerging innovations, assessing their implications for core principles through expert and stakeholder consultation, directly addressing novel issues in updated ethical standards, developing adaptive oversight mechanisms, and phasing in changes through practitioner education. ADR professional associations have a vital role to play by convening inclusive discussions to identify priority ethical risks, taking responsibility for drafting updated conduct codes, and guiding continuing training on emerging technologies. Tailoring to nuanced regional conditions across diverse BRICS nations is also key for successful ethical evolution. With vigilant advancement of standards matched by competency building, core ADR values can harmonize with cutting-edge tools for just outcomes. Key ethical issues arising from integrating technologies like AI into ADR include protecting informed consent, safeguarding confidential data, mitigating algorithmic bias risks, and saving human discretion. Regulatory gaps across BRICS economies reveal an urgent need for updated dispute resolution-specific governance. Global best practices such as the EU's AI Act, IMI's digital competency standards, and companies' advisory boards provide models for strong oversight. While foundational ADR principles should synthesize cross-border ethics, practical implementation modes must remain flexible to local contexts across diverse Brazil, Russia, India, China, and South Africa settings. With diligence and collaboration, BRICS nations can craft adaptable governance balancing innovation, international harmonization, and proven practices for responsible technology adoption in dispute resolution. Practical guidance emerging from this research includes: first, proposed code revisions to address ethical data protection, practitioner competency with new tools, and algorithmic accountability. Model language can guide incremental updates. Second, training recommendations like required certification courses on responsible AI deployment, digital ethics simulations, and clinical experiences in virtual mediation. Upskilling is critical. Third, suggested technological guidelines for ADR bodies around human-centric design, participatory monitoring, required algorithmic auditing, and saving human discretion in automated systems. With vigilant code adaptation, competency building, and oversight, core ADR principles can be upheld alongside benefits of thoughtfully governed innovation. Associations play a key role in implementing multifaceted protections. Further practical guidance includes: first, establishing clear informed consent standards for novel technologies like neuroimaging and algorithmic analytics used in ADR processes, upholding party autonomy. Second, formal confidentiality protocols for growing digital mediation, arbitration, and negotiation communications and records, protecting privacy. Third, proactive accessibility policies as virtual platforms increase, preventing socioeconomic barriers. Finally, stringent data security procedures like encryption and access controls as electronic records and data storage rise across technology-enabled ADR. Concerted efforts by ADR bodies on consent, privacy, inclusion, and security will be vital to ensure ethical technology integration across diverse BRICS legal systems. Additional practical guidance includes: first, defined AI accountability metrics like required algorithmic impact assessments, explainable decisions, and human override processes when AI is applied in ADR. Second, establishing multi-stakeholder governance boards of technologists, ethicists, ADR experts, and community representatives to evaluate technologies and recommend ethics policies. Third, phased implementation strategies for new standards like testing, extensive practitioner education, hybrid participation options, and regular expert code reviews to enable iterative, sustainable adoption. With inclusive oversight, thoughtful change management, and AI-tailored protections, BRICS associations can implement ethical evolution amidst digital transformation, upholding justice. In summary, key findings reveal the need for established ADR ethical principles to consciously evolve alongside advancing dispute resolution technologies to address emerging issues while retaining core values. Study implications include delineating this dynamic technology ethics linkage and offering actionable strategies for upright innovation. Limitations like scarce primary data on BRICS user experiences constrain robust understanding. Thus, future research priorities include comparative BRICS studies examining attitudes towards ADR tech, transparent assessment of proprietary platforms, and ongoing monitoring to continuously update recommendations amidst rapid change. This pioneering analysis catalyzes both theoretical insight and practical progress in aligning emerging capabilities with timeless virtues of justice as technology transforms alternative dispute resolution worldwide. Ongoing inclusive research can guide ethical evolution. In conclusion, key findings demonstrate the need for intentional evolution of ADR ethical standards to align with emerging technologies while saving core values. Contributions include delineating this complex dynamic linkage and providing targeted recommendations for principled innovation. Going forward, priorities include new regulations, code revisions, practitioner training, and crucially, empirical BRICS research to understand participant perspectives, enabling contextualized guidance. Comparative analysis and ongoing monitoring as technology rapidly advances will also be vital to sustain relevance. This pioneering work catalyzes progress in aligning emerging capabilities with timeless ADR virtues as the field undergoes profound digital transformation. Sustained ethical vigilance and inquiry can guide this responsible evolution worldwide. Thank you for the attention.
Thank you very much for very interesting presentation of our Professor Safoveva Sadogat, and we are sorry for her missing in our conference. And now let me give the floor to our delight colleague Andrey Rodionov. He is a PhD student and at the Institute for Professional Development and Statistical Research. He is a cutting-edge research expert pioneering application on the neural networks in alternative dispute resolution. Today, he will present an application of neural networks on analyze side behavior, shedding a new light on how AI can augment human expertise. Please join me in welcoming Mr. Rodionov. He will prepare his presentation, and now he wants to show.
Application of neural networks for analysis of sides behavior in ADR processes research perspectives for BRICS countries. Modeling ADR behavior with neural networks. Recent advances in artificial intelligence have demonstrated the capabilities of techniques like neural networks for modeling intricate human behaviors and psychology in fields such as marketing and finance. This raises intriguing possibilities for applying similar data-driven approaches to shed light on the complex behavioral dynamics involved in alternative dispute resolution processes. This research aims to explore the potentials and limitations of leveraging neural network modeling specifically for analyzing the interactions and psychology of sides engaged in mediation and related ADR methods. Key questions include identifying appropriate network architectures, data requirements, and evaluation techniques for developing models tailored to ADR contexts. In addition to advancing conceptual understanding at the intersection of ADR and AI, this research can help guide the responsible integration of predictive analytics in order to harness benefits while avoiding harmful applications. Overall, this work will provide valuable insights into how advanced AI capabilities could be leveraged to enrich ADR processes through an ethical, human-centered approach. Modeling ADR with neural networks. Alternative dispute resolution relies heavily on complex behavioral dynamics between disputing sides as they communicate, negotiate, and aim to reach mutually agreeable settlements. Advances in artificial intelligence raise intriguing possibilities for leveraging techniques like neural networks to model these intricate dynamics and gain data-driven insights into side psychology and interactions during ADR processes. This research aims to conceptually explore potentials and limitations for applying neural network modeling specifically to analyze behaviors of sides engaged in mediation and related methods. Through critical analysis, the study will deduce requirements in terms of appropriate data sources, network architectures, training procedures, and evaluation techniques suited for modeling in ADR contexts. Rather than developing actual models, the goal is to map out considerations for feasibility, interpretability, and responsible integration of predictive analytics to enrich understanding of alternative dispute resolution through an ethical AI lens. This foundational work will provide guidance for additional research at the intersection of ADR and artificial intelligence. Neural networks for modeling ADR behavior. Neural networks offer intriguing capabilities for identifying hidden patterns and subtle influences on the complex behavioral dynamics underlying alternative dispute resolution processes. Prior applications analyzing domains like fraud, deception, etc. demonstrate neural networks' potential for gaining counterintuitive insights about psychological and social factors that impact outcomes. These flexible machine learning models can generalize learnings across large datasets and adapt as new data accrues. However, significant limitations exist, including extensive data requirements, challenges interpreting complex model logic, and risks of oversimplifying human behaviors. Responsible integration should focus on complementing mediator skills through a human-centered approach, rather than replacing human discretion and versatility. Further research must explore pathways for harnessing the advantages of neural network behavioral modeling while mitigating the ethical pitfalls to enrich understanding of ADR interactions. Responsible neural network modeling for ADR. Realizing the benefits of neural network behavioral modeling for alternative dispute resolution while mitigating risks will require deliberate research and development strategies, including collecting diverse, naturalistic mediator interaction data at scale while protecting privacy, engineering interpretable models focused on precise objectives to avoid oversimplification, establishing rigorous training protocols to detect and reduce biases, developing intuitive model interfaces that enhance mediator judgment without over-reliance. The overarching aims should focus on complementing and augmenting mediator skills through responsible integration, rather than replacing human nuance and discretion. With careful advancement of these modeling techniques, neural networks could provide valuable insights to enhance mediator training and enrich understanding of core ADR behavioral dynamics. Responsible AI integration in ADR. The integration of artificial intelligence and predictive modeling into sensitive social processes like alternative dispute resolution raises important ethical considerations, including ensuring informed consent and transparency for all stakeholders potentially impacted by AI systems, engineering systems expressly to align with core ADR values of voluntary participation, self-determination, maintaining clear accountability mechanisms that identify responsibility for any harms stemming from algorithmic systems, implementing stringent privacy protections around data collection, storage, and use, promoting pluralistic oversight from diverse experts during model governance, enabling continuous refinement through monitoring systems and adapting to prevent unintended consequences. At this stage of research, AI should aim to augment human mediator capabilities through transparent decision support tools, not replace human nuance and discretion over settlement processes and outcomes. Further advancement of AI in ADR must focus first and foremost on integrations that improve outcomes for people through an ethical, human-centered approach. Responsible AI integration for ADR practice. Neural network modeling of mediation behaviors could provide data-driven insights to improve alternative dispute resolution practices, but integration approaches must remain responsible. AI-enhanced curricula should supplement existing training, not impersonally substitute for interpersonal learning. Interactive AI education tools could provide sides enriching experiential learning if balanced with human mentorship. Overall, AI systems should focus on thoughtfully augmenting ADR practitioners and participants, while human wisdom and ethical discretion remains essential. Further research must continue mapping pathways for integrating behavioral modeling that uplift human capabilities for conflict resolution. AI modeling could provide data-driven guidance to enrich nuanced alternative dispute resolution practices in thoughtful ways. By flagging potential dangers, AI could mitigate biases through cautionary signals prompting reflection. Surfacing techniques effective across cultures may broaden mediator perspectives. Modeling relationship dynamics could guide deeper exploration of side interests and values, while not replacing direct human engagement. However, integrating such AI aids into ADR practice must remain focused on selectively enhancing human capabilities, rather than impersonally automating the inherently subjective art of mediation. Discretion over whether and how to apply modeling insights should remain with ethical, qualified mediators devoted to principles of conflict resolution. This conceptual analysis revealed intriguing possibilities, but also risks and open questions surrounding the application of AI techniques like neural network modeling to provide insights about mediator and side behaviors in alternative dispute resolution contexts. Key issues requiring further research include empirically validating feasibility assumptions made in the theoretical inquiry, soliciting broad input to inform responsible human-centered design, and extensive testing to prevent potential harms. Technical safeguards must be developed to mitigate risks stemming from biases encoded in training data and lack of model transparency. Differences between paradigms of conflict resolution also warrant examination to avoid imposing biased assumptions. Overall, collaborative interdisciplinary research will be critical for advancing AI in ways that enhance mediator capabilities while aligning with mediation's core values and ethics. Prudent exploration of this emerging intersection of technology and conflict resolution can yield AI systems that provide nuanced data-driven insights to augment alternative dispute resolution theory and practice. This conceptual analysis suggests neural network modeling techniques have promising capabilities for developing data-driven insights into mediator and side behaviors. However, realizing benefits will require extensive research to address challenges surrounding data sufficiency, algorithmic biases, interpretability, and effects on mediation practices and ethics. If thoughtfully designed and deployed, AI could provide tools to enhance mediator training and strategy. But premature application without safeguards risks undermining human expertise and dignity essential to conflict resolution. As a conceptual inquiry, limitations include lack of primary data and empirical validation. However, the study contributes an analytical framework and highlights critical issues warranting exploration at the intersection of AI and alternative dispute resolution. Further research directions involve investigating diverse viewpoints to guide design, proposing legal frameworks to govern use, and monitoring deployments to enable continual improvement. Through deliberative inquiry, future work could responsibly advance AI and ADR by selectively leveraging modeling capabilities while prioritizing human wisdom, ethics, and well-being. Thank you for the attention.
Thank you, Mr. Rodionov, for that integrating view on the using neural networks to better understand sides conduct in mediation and arbitration. And now, just because of time, I will do the closing remark. I sincerely thank a lot of our speakers for sharing their wisdom over the past 2 hours. It has been true privilege to participate in this dialogue on this cutting-edge dispute resolution. Based on our discussion today, I propose we collaborate to produce a summary document outlining key recommendations from the session to guide other innovation in the BRICS alliance by the and beyond. Furthermore, our speakers should come together to contribute articles on these virtual topics to leading academic publications. Tashkent State Law University and the Tashkent International Arbitration Center, TIAC, also invite partnership with the Theo of Brazilian Center of Mediation and Arbitration. We would be honored to sign cooperative agreements between our institutions to advance mediation globally. This is just the start. We look forward to continue collaboration online and offline in the future conferences. Thank you again for contributing to this moment's conversation. The future ADR has been never looked brighter. Dear colleagues, it has been a pleasure to connect with you all virtual today. While we lack the ocean here in Uzbekistan, we would be delighted to join you in person for the next Rio de Janeiro conference and enjoy the sights and sounds of the city during our free time, perhaps taking in the spectacle of the carnivals. Although we were apart today, technology allowed us to unite across borders. I look forward to the day when we can meet face to face to continue our important discussion on the future of the ADR. Until then, I wish you all the best Let's stay connected. See you soon. Bye.